Welcome to The Explainer. Today, we're looking at how a localized dispute in a muddy asparagus field in New Jersey ended up triggering a massive nationwide constitutional debate. We're going to explore a case that strikes right at the heart of how our government operates, specifically looking at the sweeping legal impact this could have on the judicial power of federal administrative agencies. Okay, let's dive into this. Can a single government agency investigate you, charge you, and then try you in its very own internal court? Well, for decades, the answer has largely been yes. But recently, a fourth-generation family farm decided to challenge that exact system, arguing that they were being denied their basic constitutional rights to a truly independent federal court. Here is our roadmap for today. We'll start with the farm labor dispute itself, and then zoom out to look at the DOL's internal courts, the Jarkesy precedent, the boundary between public and private rights, the impact on enforcement, and finally, the impending Supreme Court showdown. Let's get right into it. Part 1. The farm labor dispute. And this brilliantly illustrates the core conflict. Back in 2015, Sun Valley Orchards hired over 140 domestic and foreign workers to harvest crops, signing a federal contract that guaranteed some very specific conditions. But look at the massive gap between what was promised on paper and what the Department of Labor claimed to actually find in reality. The contract promised safe, OSHA standard housing. Investigators found insect-infested camps and mattresses on the floor. The farm promised free cooking facilities, but the DOL found workers were placed on a mandatory meal plan costing up to $75 a week. Safe transportation was promised, but the reality included vans with bald tires driven by unlicensed drivers. Finally, when workers complained, the DOL found that some were forced to leave early, completely violating their guaranteed work hours. Now, the farm owners fiercely contested this. They argued that a prior inspector had told them everything was fine and that they were being ruined over what mostly amounted to a paperwork mistake. Part 2. DOL Internal Court Adjudication. When the agency formally accused the farm, they didn't file a lawsuit in a traditional courthouse. They kept it all in-house, assessing a staggering combined total of over $550,000 in civil penalties and back wages. Facing those kinds of ruinous fines, you can see why the farm owners felt the system was rigged. To fight these fines, Sun Valley Orchards had to go before an administrative law judge, or ALJ. Basically, this is an in-house judge employed by the executive agency itself. They operate without a jury and completely outside the bounds of an Article III federal court, meaning outside of a truly independent court established by the Constitution. For nearly 5 years, the farm fought these fines within the DOL's own administrative system. And at every single stage, the agency's internal reviewers upheld the vast majority of the penalties. Part 3. The Jarkesy ruling precedents. After exhausting all those internal appeals, the farm finally took their fight to a real federal court. And honestly, their timing was absolutely perfect. It coincided right with a major 2024 Supreme Court decision called SEC v. Jarkesy. Relying heavily on that brand new precedent, the Third Circuit Court of Appeals delivered a stunning victory for Sun Valley Orchards in July 2025. They essentially utilized Jarkesy to vacate the DOL's fines, ruling that the in-house adjudication of this case was actually unconstitutional. So, the crucial point is exactly why the court ruled this way. They dug into the historical nature of the penalties. The court determined that seeking monetary fines and punitive back wages are traditionally common law actions. That means they are designed to punish defendants, not just fix a mistake. Because of that, the Constitution demands defendants facing these civil penalties be entitled to a trial in an independent Article III federal court, not a hearing with an agency bureaucrat. Part 4. Public versus private rights. Now, what's really interesting about this slide is how it highlights the intellectual heart of this entire dispute, identifying the deeply contested legal boundary between public and private rights. Public rights involve things like immigration, border control, tariffs, and taxation. If a case is about public rights, an agency generally can use an internal judge. Private rights, however, involve things like contracts, tort law, and breach of employment between individuals. Those require a real federal court. The DOL argued that because this involves the H-2A visa program, it's a matter of public immigration law. But the Third Circuit totally disagreed. They ruled that the farm's job order was essentially a private employment contract. The dispute wasn't about the admission of aliens, it was about domestic contract issues like housing, meals, and wages. Therefore, it was a private right requiring a real trial. Part 5. The impact on agency enforcement. So what happens to the DOL's enforcement capabilities if agencies lose this power? Well, the Harvard Law Review published a pretty short, neutral critique of this, arguing the Third Circuit actually confused some basic legal concepts. By classifying back pay and its deterrent effect as a legal punishment requiring a jury, rather than an equitable remedy just meant to make the workers whole, this ruling creates a potential nightmare scenario for the Department of Labor. It risks requiring jury trials for all sorts of equitable remedies, exposes the agency to wildly inconsistent judgments across the country, and frankly could severely chill their ability to quickly enforce protections for vulnerable migrant workers. Part 6. The Supreme Court Final Showdown. Let's move to and see how this builds, because with these kinds of macro-level implications, a local farm dispute was never going to end at the appellate level. Trace this 11-year journey with me. What started with an inspection of pepper and asparagus fields back in 2015 led to penalties in 2016. It sat through years of internal administrative appeals, caught the massive wave of the 2024 Jarkesy Supreme Court precedent, resulted in that stunning reversal by the Third Circuit in 2025, and has now, as of April 2026, officially been taken up by the Supreme Court. Which leaves us with a truly profound question to ponder. What is the future of the American administrative state? If the Supreme Court sides with Sun Valley Orchards, the legal boundaries of public and private rights will be totally redrawn, and government agencies might permanently lose their internal judicial power to enforce labor laws and assess penalties. Will the pursuit of constitutional fairness for small businesses end up dismantling the government's ability to protect the most vulnerable workers? We're going to find out very soon. Thanks for joining me on this explainer, and keep questioning how the system works.